Good morning, everyone. I see that the number of participants in the Zoom call is still rising, but I'd like to take the opportunity to welcome everyone. My name is Gus Van Harten. I'm a professor at Osgoode Hall Law School. We have a very interesting seminar for you today. I'd like to very quickly introduce our guests. I won't take too much time doing that. We'll begin today with a presentation for approximately 12 to 15 minutes by Ladan Maranvar and Lisa Johnson. Ladan is a senior legal researcher at the Columbia Center for Sustainable Investment, and Lisa Johnson is a senior fellow at the CCSI and also counsel at the law firm Curtis Millay, Prevost, Colt and Mosel. We then have three wonderful commentators on the presentation. The first is will be Ariana Arce, who's with the Directorate of Investment and Cooperation for the Ministry of Foreign Trade of Costa Rica. Welcome, Ariana. We also have as a commentator Kabir Dougal, who's a senior international arbitration advisor with Arnold and Porter and a lecturer at Columbia Law School and a senior fellow at CCSI. So welcome, Kabir. And we also have as a commentator today, Jeremy Sharp, who's an international arbitrator and international law consultant and a lecturer, and also is formerly with the U.S. State Department in its arbitration, international arbitration branch. So thank you very much, Jeremy, as well, for joining us today, and welcome. And without further ado, I'd like to turn the Zoom screen over to Ladan and Lisa to hear their presentation. Thank you.
Great. Oops. Sorry, just covered up my screen. Okay, there we go. Thanks to CCSI for the invitation, and to all of you for joining us, and to Gus and all the panelists for also being willing to kind of talk about this paper that Ladan and I wrote. Ladan and I will alternate going back and forth, providing an overview of the paper. And I'm just going to start with a bit of a background of why we wrote it. When we did so, we were motivated by three factors. First, the concerns that are often expressed, including in UNCITRAL Working Group 3, that tribunals are generating incorrect interpretations of investment treaties. And second, we were influenced by the prospect that states, as masters of their treaties and per the Vienna Convention on the Law of Treaties, could use their voice to shape interpretation of their treaties and thereby avoid or address incorrect readings by tribunals. And third, we were curious about the role of interpretation as a corrective or control mechanism actually in practice. So we wanted to look at the data. How has it actually been used, been applied? And so while, of course, there are different ways of forming subsequent agreement that, pursuant to the Vienna Convention on the Law of Treaties, the VCLT, that must be taken into account by tribunals, we focus specifically on the formation of agreement through state submissions to tribunals in the context of disputes. So those submissions constitute state practice, and when the submissions of the treaty parties match, they can form this agreement that tribunals are to take into account per Article 31(3)(b) when interpreting the relevant treaty. So today we will discuss what we found, the data, and now I will turn it over to Ladan to dive into that.
Thanks, Lisa, and thanks, Gus, for the introduction. So as Lisa mentioned, in order for submissions to constitute state practice, input from both parties to a treaty must match. In ISDS cases, tribunals are provided with the input from the respondent state, but what about the input from the home state, or as they are called, the non-disputing treaty party? So for this paper, we collected the data on the prevalence of non-disputing treaty party submissions in ISDS cases by reviewing all publicly known treaty-based claims. And this included looking through awards, procedural orders, party submissions, hearing transcripts, and company press releases. So in total, we included 450 cases in our data set. These are decisions that are upholding claims in part or full, so where the investor wins, and decisions dismissing all claims, so where the investor loses or the respondent state wins. We didn't include settled, discontinued, or pending cases or annulment decisions. Further, as you will see in a second, we divided the data into four main categories: those cases under the NAFTA, the CAFTA, and the ECT and other treaties. So the data that we collected shows three main findings. One is that home states generally do not provide any input into these disputes. So as you can see from this graph, only in 4% of cases brought under investment treaties did the home state weigh in as a non-disputing treaty party. And the majority of those cases, those 4%, with home state input, are cases in which Canada or the US was the home state and they provided the input. The exception to this finding is the practice of a few states under two treaties, namely the NAFTA and CAFTA. State parties to these two treaties are quite active in submitting input to tribunals, so even when they're not a disputing party. So these two tables further highlight this finding. The table on the left shows the top 10 home states. So these are the home states of the investors. To take one example, the US has been a home state in at least 91 known cases. And so it has had 91 opportunities to provide input during those disputes. But it has only provided input in 30 of those 91 cases and has limited its input to clarifying 7 out of the 24 treaties that were invoked. And out of the 7, 2 of them were the NAFTA and the CAFTA. Canada follows a similar pattern, but with fewer cases. And although the rate of engagement of the US and Canada are limited, they far surpass that of other major home states. So as you can see from this table, the Netherlands has had at least 45 opportunities to clarify the interpretation of its treaties, but has provided input in only one case. And in that one case, it was invited to do so by the tribunal. The pervasive disengagement by home states is further illustrated in the table on the right, which lists the top 10 respondent states, the majority of which are capital importing states. And you can see here again the lack of engagement by their treaty counterparts during ISDS proceedings against them. So the home state of the investor in these disputes almost never provides inputs, with the exception of cases against Mexico and Canada, and that's under the NAFTA. The second finding is that there appears to be a correlation between non-disputing treaty party submissions and respondent state success rates. However, it's impossible to say that one causes the other. So as you can see here, the success rate of states under the NAFTA and CAFTA is higher than under the universe of investment treaties more generally. Recall that in the NAFTA and CAFTA situation, there are a lot more input from the non-disputing parties. And this is probably, and Lisa will get into this, this is probably because the interpretations provided in these submissions tend to narrow rather than expand treaty provisions. The third finding is that when you look at investment treaty disputes, you generally have two categories of states. One, you have home states, which are the capital exporting states, and two, you have respondent states, which are often the capital importing states. And under any given investment treaty, you generally don't have states switching places. So if you're a respondent state under a given treaty, you're usually always a respondent state under that treaty and never home states. So states have a defined rule and they generally don't swap back and forth. There are exceptions under multilateral treaties. One big example, of course, is the NAFTA, which is much more dynamic. Capital flows both ways. And so at the bottom of this graph, you can see that Canada and the US have been both the respondent and home state in a number of cases. But generally under their other treaties, so on the left side of the graph, they are almost exclusively home states. So other examples are Spain. Spain under other BITs is usually the home state, so the blue on the top. Under the regional treaty, namely the Energy Charter Treaty, it's the respondent states. But other countries are one or the other. Okay, I'm going to turn it to Lisa now. Thanks.
Thanks. So there's a lot in there that and it took Ladon a lot of effort to kind of unpack and dig through the cases and find evidence of when there was non-disputing treaty party engagement and when there wasn't. So we were happy to talk more about the data and the findings. But in terms of what we thought about the implications of this is that maybe, wait, Ladon, could you go back to that last slide that it showed that numbers, with the 91 of the, I guess it wasn't the last slide, but the 91 from the US and 45 from the Netherlands. I mean, what we saw from these figures is that there were kind of really missed opportunities to establish subsequent practice that must be taken into account by tribunals. So as we know, as we said, Article 31.3b provides that if there is subsequent practice by states establishing agreement regarding the meaning of their treaty, that this agreement shall be taken into account by tribunals. But here you have this persistent silence by home states, means that respondent states, they can't get a match, right? They can't get an agreement. So for this agreement to form, you need your treaty parties to be doing or saying the same thing. But what we're seeing is that the respondent states are saying something when they're sued, and the non-disputing treaty parties are staying silent. And then rather than interpreting the silence to reflect the absence of a dispute between the treaty parties or agreement between them, that silence, I would argue, is essentially treated as an indication that there is a disagreement. So the host state's input on its treaty, it carries no special weight relative to the input of the investor. Unless or until the respondent states are able to get this match, this agreement, I think the promise of subsequent agreement as a control mechanism will remain more of a mirage for them than something real. So they become systematically sidelined in their efforts to shape interpretation of the treaties. So after identifying this systematic sidelining and talking about kind of the implications of that, we started to explore why non-disputing treaty parties might or might not engage. These, again, are typically the home states, why they might engage or why they might stay silent. And then from better understanding the reasons, then we decided to kind of propose some ways forward, either to encourage non-disputing treaty parties to provide input, or at least to prevent that silence from kind of effectively penalizing host states. So the possible reasons for disengagement. So this first point, that states do or do not have defensive interests under the relevant treaty. This relates to that defensive, offensive balance, home state, respondent state. So while it is true, of course, that there is more and more investment coming from global South countries into the global North, and that there are more and more South-South treaties, that what we saw in the data, that under the majority of BITs that are in force and that are being used in ISDS cases, the capital flows are predominantly unidirectional. So that means some states have defensive interests and some offensive. And for those with offensive interests, they might not have a strong desire to clarify the content of their treaties in ways that narrow the protection for investors. The identity of the investor and the nature of the issue at stake might also be important factors that shape motive. So for instance, that motive might be particularly strong when the perceived threat is not just economic, but maybe to a more systemic issue like the relationship between EU law and investment law, which could be driving EU engagement as a non-disputing treaty party under the ECT, for instance. Now, another reason that we talked about and highlighted in the paper is that some states contend that to get involved in a dispute as a non-disputing treaty party is actually to politicize disputes, and that the ISDS system was designed to kick home states out of the dispute, and non-disputing treaty party engagement would just bring them right back in. So another reason is that they might just not have a practice of doing this. It's not something that has really worked its way into the job description of a government official who deals with investment treaties or defending claims against the state. So here again, we see that maybe the NAFTA states, and they developed a consistent practice of providing non-disputing treaty party input. And it is a couple of those NAFTA states that have been among the few states that also have provided that input into disputes under bilateral investment treaties, notwithstanding that they have relatively asymmetrical investment flows. So for states that maybe don't have the practice of providing this input, there are costs associated with developing it, and there may be concerned that the costs don't outweigh the benefits. An additional reason for why states may not engage is that they may not know. Investors might not notify their home state that they have filed a claim. The case might be confidential. Home states might not know the arguments being raised or understand why they might have an interest then in clarifying a particular issue. So we see that again in those cases where non-disputing treaty party input was common or was done, those treaties did provide for transparency, or the practice of the states was to provide for transparency. That could also be a factor. Relatedly, that was the Lauga Paulson's work was that states don't really perceive that there's a threat, right, until they're sued. So also until maybe a home state is sued, they might not really think that there's an issue with interpretation. So just moving on, wrapping up, moving on from some of these causes of potential disengagement, we look at what are the possible solutions, like how can we encourage more constructive engagement from the home state, or at least, again, how do we ensure that host states are not penalized by the fact that the home states are silent? So one is we can give more weight essentially to home state silence. We can treat it as legally significant acquiescence under international law. So you can form agreement by silence. Or per the treaty, you can provide that in the absence of input from the non-disputing treaty party, that the respondent state position is given presumptive validity, or the home state is deemed not to disagree. You can facilitate it by ensuring transparency of investors' claims and submissions. You can also, I think, create mechanisms for kind of having guidelines around when and on what issues the home states should weigh in. So reducing discretion, but also making that whole process of home state management of their treaties much more public, much more open, similar to how the process might be around conclusion of a treaty or management of a treaty more generally. We can require non-disputing treaty parties to engage constructively and in good faith regarding issues of interpretation when they're approached by the respondent home state. We can require treaty parties to approve claims before they proceed. It's just another mechanism for getting the home state to be more involved in the dispute. So those are some of the ideas that we suggest in the paper. There are some others, we explain them more, but I will stop there to leave more time for discussion. Thanks.
Thank you very much for the informative and well-researched and documented presentation. I wanted to let everyone know who's joining us today that if you have questions, you're welcome to use the Q&A facility in Zoom, which you'll see at the bottom of your screen. You can pose your question. I and the panelists will all see the question, but it will not go to the general audience, and we'll do our best to answer any questions that come in. I also want to quickly mention that this is a recorded meeting in case you didn't get that notification when you joined. So now I have the pleasure of moving to commentaries from our three commentators, and I'm hoping to hear from them fairly briefly, about a 5 to 7 minute intervention, leaving some time for Q&A or discussion amongst those who've joined us today at the end of later in the hour. So we'll start first by hearing from Ariana. Ariana, the screen is yours. Please go ahead.
Thank you so much, and good morning, good afternoon, good evening to all. I would like to start by saying that it is such an honor to be part of CCSI's speaker series, and also would like to thank Lisa and Layden for the kind opportunity of commenting on this fascinating article, truly. Choosing a specific section or element to comment on was a difficult task because the article provides food for thought on such a variety of arguments, but I would like to focus on the section that resonated with me the most, perhaps due to my experience as an advisor to a state, and how I've seen non-disputing treaty party participation unfold in practice. So I think Lisa just explained that the article develops 5 different factors that may contribute to the silence from home states. But I would like to concentrate on 3 that I believe are key, are interrelated, and could actually be used as leverage by a respondent state. So the first one is to politicize or not politicize, right? This is a great question that is posed by the article. And this is also linked with defensive interests of a home state. So I found it quite interesting that the article actually highlights the fact that ISDS and political engagement at the state-to-state level coexist and also complement each other. Diplomatic channels are also used in ISDS cases or are often used at the outset of a dispute, which might facilitate communication between the home state and the investor and the host state, improve the chances even of reaching an agreement or even alerting the host state that there is an imminent dispute. So diplomacy and protection of investor rights are only one of the elements in the creation of investment public policy. And I think this is very important for us to always bear in mind because investment policy is an umbrella which covers topics such as diplomacy, attraction, investment attraction, negotiation, and defense. And this is the case for capital exporting and capital importing states. So respondent states can actually benefit from the fact that capital exporting states also have an interest in the defense, even though we absolutely agree that some states don't have the opportunity of being respondents as much as others, but I think that global discussions at various levels, such as UNCITRAL, OECD, UNCTAD, and even ICSID, have drawn attention to the importance of coherent interpretations and appeal to this defensive interest of the home state. And one of the things that respondent states can actually harness is the interest of these capital exporting states that have been developing a very linear negotiation public policy in saying, well, if this specific provision in this treaty is misinterpreted by a tribunal, this can have a domino effect on other of your treaties. And I think this is very important to keep in mind. And to just, as a conclusion, diplomacy and defense are triggered in different times. And I think this can be used by the respondent states. The second one, the second factor is that the home state is unaware of the claims its investors are filing. And I think this is actually one of the most important factors for disengagement, at least in my practice. When Costa Rica has faced the need of non-disputing treaty party submissions as part of our defense strategy, we have tackled the issue with one idea in mind. And this is that participation from the other treaty parties does not happen on its own. It's part of our defense strategy. It's part of what we have to do in order to win the case. The home state, and this has been truly our experience, could be unaware of the details of specific cases, and dispute settlement teams might not be aware of what the arguments by the investor are. They might not even have access to the submissions due to lack of transparency rules, or not have information on what interpretation is being offered by the investors to the tribunal. So in this regard, constructive communication with your treaty counterpart is key. And this has been our experience in CAFTA. Of course, CAFTA has different mechanisms that also encourage non-disputing treaty party participation. But I think that a lot of respondent states that have currently ongoing CAFTA cases, Costa Rica hasn't had a CAFTA cases in a couple of years, but we've seen really great practices from respondent states. For example, reaching out with the defense team and counsel to briefly explain what the case is about, indication of what standards are being discussed, what the importance of or rather what the interpretation of the investor is, and why it's so key in that particular case to make a non-disputing treaty party submission. And I think that has worked wonders for us, because truly I have been in these meetings trying to be convinced of submitting a non-disputing treaty party submission, and it really makes a difference. And the third one, just to mention this really briefly, is that the home state does not consider the benefits of engagement outweigh the costs. And in this is quite related to what I was saying before, because additional to costs, I think we should consider time. Writing a non-disputing treaty party submission is very time consuming, especially because we have to go through submissions, really make sure that we understand the arguments of both parties, and then offer our own interpretation. And this is to be taken obviously even more seriously now that transparency rules are in place, for example, for ICSID, which we absolutely agree with. But now there is a heightened sense that defense officials have to be the keepers of a very solid public policy in the defense and interpretation of our treaties. So also having that engagement with your treaty counterpart, I think, solves a little bit of this time-consuming issue, and has actually resulted in positive benefits in terms of our practice in non-disputing treaty party submissions. So I will end there, and thank you so much. I'm open to any questions you may have.
Thank you very much, Ariana, for very insightful comments. I'm going to move in a moment to Kabir, but I just wanted to mention there are a few questions that have come in the Q&A board. I'm going to save those until a little bit later in the discussion for now, but I will post one interesting comment to the chat about a similar research project being conducted at UCL. Thank you all for the questions so far. Now I'd like to turn the screen over to Kabir. Please go ahead.
Thank you. Very delighted to be here, to be with friends. We're on a Zoom reality, but it's still really nice. Let me just begin by highly recommending this paper to everyone to read. Don't let the 45 pages frighten you, because it is an easy read and it's a practical read. I think, you need both of those. So I really do recommend everyone read it. Now, I thought it may be a helpful approach for me to talk about the issue at large, looking at the role of states and the role of tribunals. Why am I doing this? Because there's nothing in the paper that I disagree with. In fact, I think I would only strongly endorse that message. But I think it is, interesting for us to be thinking about how might all this play out in a dispute. So if we look at it as an issue to be understood from the state perspective, we've heard both our author presenters tell us that states are the masters of the treaty, and it is absolutely pivotal that states step in and take control over this process. It is honestly a little entertaining and amusing to see the lack of engagement at a macro level. And so I do think we're putting a disproportionate burden on states. But if there is a gap, or if there is a perceived gap, and that gap is not plugged, it's not filled, tribunals will step in and fill it, and tribunals can fill it however they want. So I do think this is really important. You do this interpretative process. You can do it in a variety of different techniques. The paper walks us through several of them. I just also put out that there may be two issues we want to think about. There seems to be a temporal issue. When do you delve into the interpretative process? Now, I think it's fair to say, do it whenever you can. It's better that you do it than you don't. As a general matter, having said that, it's probably better if you do it before a dispute arises. NAFTA state parties got lucky, not everybody does. And the second point is, is the interpretative process consensual, or is it just one party doing it? Is it a unilateral declaration? Is it a consensual declaration? Again, it is better that you do it unilaterally than not. But if you can get consensus, it's always better to do that. I just do want to point out the other aspect, and I promise I'll stop with this, Professor. Will interpretation and all these techniques necessarily result in better decision-making by tribunals, more thoughtful decision-making? And honestly, the jury is out on that. You had Echo Oro versus Colombia. Both Canada and Colombia come out telling us what they understood the treaty to mean. And there is some amount of, honestly, as a yoga practitioner, there's some amount of twisting your body in ways that really hurts my mind. But they completely disregarded what was put before them. So why is interpretation still important? I think it's important because it will empower states to think more thoughtfully about the reform process. It does kill me a little bit when I read the discussions at Working Group 3. Because, this is when you have a body suffering from cancer and the remedy being given is, let's put a Band-Aid on your hand. And some of these meta macro questions that the authors are identifying are completely out of the scope of Working Group 3. And maybe it is necessary for us to bring some of that into these meta 10, 15-year reform processes to make our system better. Once again, everyone should read the paper. Neither of the author is giving me commission, so my words are true. And with that, I will stop.
Thank you very much, Kabir. I should have disclosed my own commission for this event. No, I'm joking. No, I'm also not receiving any. No one is. This is a scholarly, open access event. Please feel free to speak your mind. Again, lots of questions coming in. I'll return to those as moderator after we've had the pleasure of hearing from Jeremy as our next commentator. Jeremy, over to you.
Thank you very much, Gus. I'll try to make this very short so we have time for discussion and questions. I also want to congratulate the authors. I think it's a really important and timely piece. The states often do appear to be missing masters in investment law and arbitration, and we've heard the problems that arise from their not playing the role that perhaps they could to keep investment arbitration on a proper course, and including some of the main issues that have been discussed in Working Group 3, like a lack of proper interpretation by tribunals or a lack of consistent interpretation where consistency is warranted. I thought I could highlight two issues that haven't been discussed very much. And some of these arise from my own experience. As Gus mentioned, I used to work for the US State Department. I've represented other states. Of course, I'm speaking in a personal capacity, but it has informed the way I think about some of these issues. So two major risks that are highlighted in one way or another by the paper. The first is the very structure of investment treaties, where the investment treaties delegate to private parties the authority to bring cases directly and to advance legal arguments under the treaties. And at the same time, of course, the claimants generally lack defensive interests under the treaties. So unlike states, the claimants have every incentive to advance any available argument to win their cases without the fear that those same arguments could be used against them in later cases. So an argument advanced by a claimant, such as, legitimate expectations as a foundation of fair and equitable treatment may be adopted by a tribunal and then become a precedent or a jurisprudence constante. Now, this is different from some other institutions, and as Lisa mentioned, some international claims commissions, for instance, the home governments retain the right over the claimant's case, including, for example, by signing off on the claimant's pleadings by the state agent. And this gave the home government significant control over the treaty. That's obviously not the system we have with investment treaty arbitration, which is why it's critical that both treaty parties can weigh in during the dispute to try to keep the law on proper track, try to make sure that the interpretation that the two states parties had considered when they adopted the treaty is adopted by the tribunal. The second risk I want to highlight is the issue of decentralization. We have a decentralized investor-state dispute settlement system, investment treaty arbitration system. If we think of an institution like the WTO, we have an international organization in Geneva, and the regime for international trade then is largely institutionalized around this institution. And this has consequences at the international and domestic levels. At the international level, you have states with common treaties, common legal obligations, common means for resolving trade disputes. And in principle, all of the participants in the WTO system, they understand their rights and obligations. They understand the mechanisms for protecting and defending those rights. And there's an international community of trade officials that exchange ideas around the WTO. But this lack of institutionalization also has consequences at the domestic level. States can organize themselves for trade around this institution. States can have an office in Geneva, they can have officials in capital, they can receive specialist training, for instance, on WTO law from the WTO Advisory Center. And as part of WTO accession, the states adopt laws and regulations and practices domestically to facilitate membership and legal compliance. So the process is institutionalized, which facilitates bureaucratization. ISDS is very different. ISDS is not institutionalized. It's perhaps less susceptible to bureaucratizations. So when states started concluding international investment agreements, they generally did not establish an office with a bureaucracy to deal with ISDS. And as a result, many states had no leadership for ISDS. They had no cadre of subject matter experts for ISDS. And many states were not well prepared to defend themselves in ISDS cases. The states tended to be reactive and not proactive. They tended to be ad hoc and not systematic in their approach. And they tended to focus on ISDS episodically and not consistently. And so many of the problems, from my perspective, that we see in investor-state dispute settlement flow from this lack of institutionalization. And the missing masters problem, I think, is part of this broader challenge. And so I really commend Lisa and Ladan for not just highlighting this, but for proposing some solutions. It's interesting, I was listening to Kabir's observations about Working Group 3, and I thought about this a little bit differently, because it seems to me the most important thing that's coming out of Working Group 3 right now is not necessarily the products they're working on, but the effective institutionalization of this problem. States have begun coordinating amongst themselves internationally and domestically, and the capacity building that's ongoing at the domestic level, to my mind, might be one of Working Group 3's most important and long-lasting legacies. And as a consequence, many of the reasons I think that Lisa and Ladan identify for why states do not provide non-disputing party submissions when they have the opportunity flow from these lack of institutionalization, lack of awareness, and so forth. And so the work at UNCITRAL Working Group 3 is really helping educate state officials, but also providing a forum for discussion and formal and informal networks that is essential for the proper functioning of the system, including for the use and continued development of non-disputing party submissions as an opportunity to control the proper development of international investment law. So perhaps, Gus, with that, I'll stop and look forward to the comments and questions. Thank you.
Thank you, Jeremy. Very, very thoughtful comments and much appreciated. I am going to ensure that Ladan and Lisa have a chance to respond to some of these excellent comments, but I'm conscious of time and I don't want to ignore the questions in the Q&A entirely. So what I'm going to do is put one question from the Q&A to each of our commentators. Unless I see waving hands expressing non-consent, I'm going to do that. And the first person I'm going to put a question to will be you, Jeremy. I hope it's okay. Feel free to pass on it if you wish. I'm going to synthesize the question. It's from Sergei Grishko, who's attending. And the question is essentially, why do NAFTA countries are relatively so active in submitting non-disputing party briefs, especially in the NAFTA context? And is that really just because they're more likely to be sued under NAFTA than they are under other treaties? Any thoughts?
Yeah, thank you. I do. I mean, I think there are a lot of reasons, including transparency that Ariane mentioned. They're aware of these disputes. But I really think it has a lot to do with institutionalization. The NAFTA parties created an institution, both domestically and as between the three parties, to deal with issues arising under NAFTA Chapter 11, the investment chapter. And therefore, precisely as Ariana was suggesting, when a dispute comes in, you already have contacts in foreign governments. You're quite aware of their practice, their treaty practice from awards and from having reviewed their public submissions. And you know where an interpretation advanced by a particular claimant might diverge from the positions taken by other NAFTA parties. So you have the informal networks to have the discussion. You have an awareness of what the other state's practice is, and you have regular means for communicating to ensure that there's an opportunity regular practices in place, so there's an opportunity for the non-disputing party submissions to intervene, such as each of the NAFTA parties going to the first session aware that non-disputing parties should be built into procedural order number 1 to make sure that the parties, the tribunal is aware and the other party is on board. Now, the flip side is take the US experience with another state where we didn't have these relationships. Outside counsel was hired. US wasn't aware of the case, learned about it after a hearing, and only then had to write to the other state, the tribunal, and the claimant said, look, we have a right under this treaty to make a submission. It came after the hearing. That's not a kind of approach that you want. You want an institutionalized approach where the state council are coordinating regularly about their disputes. And I think once that's in place, the non-disputing party submissions are much more likely to flow and much more likely to be effective. Thank you.
Thank you, Jeremy. Thanks for those further thoughts. The next question, I'm going to break it in two and pose one aspect to Kabir and the other to Ariana. So let me state the two questions. The question overall is from Arga Kumarjana, and I will apologize for any mispronunciation for anyone's names. The first part of the question for you, Kabir, is this: is there really a solid legal basis and avenue in international law for non-disputing party states to be intervening in these ISDS cases when the treaty itself does not provide for such interventions in the manner of, say, NAFTA? So that's the question for you, Kabir. And just to give her more notice, I'll let Ariana know the question for her related to this is, can intervention in ISDS cases, can it backfire? Okay, so Kabir, over to you.
So let me just start off. Look, tribunals tend to be formalistic. They like to see that they have a mechanism. And when you have an express mechanism for non-disputing parties, it's very easy for the tribunal to say, by virtue of rule blah, 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 we are going to allow non-disputing party submission. So that's easy. If you don't have that, the states have still created the treaties. There's nothing that prohibits them for putting out a statement generally what tells you what they understood the treaty to be. So that mechanism as a general matter of international law and treaty interpretation exists. Now, if the specific point is that you want to take your interpretation to the tribunal, it will be complicated, but not impossible, just to bring a motion before the tribunal and say you would like to intervene and clarify certain points. Now, there's a lot within this question because it assumes that all the pleadings are in the public domain, that the home state has read and studied them and is aware. A lot of these are not points we can take for granted. You know, the investor may not have spoken to the home state. If it's a shell company, it's complicated at all kinds of levels, right? But assuming that we don't have some of these limitations, there's nothing to prohibit the home state for saying, hey, tribunal, we are one of the state parties, it's our investor, and we'd like to clarify what we think the treaty means. So I think, you know, a lot of this could be worked out. We hope we have tribunals that are willing and thoughtful to engage. Unlike Jeremy, I'm a lot less optimistic about the system at large and the way it operates. You know, some of these things also, like amicus briefs, like non-disputing party submissions, there's a freedom to allow things in. There is no obligation to engage, and the jury is completely out as to what the tribunal does with all these things. But at least from a procedural perspective, in either situation, I think it's not an impossible task. I'll stop here.
Thank you, Kabir. I'm reminded of the saying, a pessimism of the mind and optimism of the soul. So perhaps Jeremy is simply speaking more from the soul. Ariana, over to you with the other question. Can these interventions backfire?
In my experience, well, I'll say the first thing. My first thought is, of course, it can backfire, you know, of course. But I think that, as I said before, and Jeremy was also commenting on this, I think there is much more of a global consciousness of the issues that we're having in ISDS and standard interpretation. And I think even capital exporting states have this consciousness and have engaged very actively, not only in these global discussions, but also have created, designed new provisions with very well thought out language, because they also know that of the risks of having provisions that are not interpreted correctly. So I think that I guess the answer is yes, it can backfire, but I think that the risk of this is decreasing because of these widespread discussions that we're having, and in this understanding that we're all developing on what are the issues that ISDS entails. And I can tell you from experience, at least, I've had a number of non-disputing treaty party submissions in NAFTA and also in CAFTA, sorry, and also Canada in the Infinito case. These have all been fabulous non-disputing treaty party submissions that have, some have had benefits and some haven't translated to the award, but some cases and some tribunals have truly engaged with these submissions, and this has made a difference in the cases.
Thank you, Ariana. I'm conscious we only have 10 minutes left, and there's no way I'm going to get to all the questions. I'll apologize in advance. And I do want to allow Ladan and Lisa to say whatever they'd like, but the shorter your pithy comments, the more I can go back to one or two more questions. So maybe focus on one or maybe two things that really stand out for each of you. Please go ahead. Shall we start with Ladan?
I was going to actually suggest, Lisa, I think you want to answer some of
Sure.
No, I mean, I'll be super quick, but thanks to all of the comments and questions. And it was really nice to hear from Ariana that some of the theories that we put forward as explaining disengagement actually kind of resonated. So it's nice to hear that, and it would be good to kind of continue the discussion on, the extent to which maybe other theories resonate with different states. But that was nice, and it was also good to hear from Jeremy that example of home state more active control and whether a claim can go forward, because it was again something we were hypothesizing about but weren't so familiar with the actual practice.
Thank you, Lisa. Ladan, did you want to add anything?
Well, I was going to go to the questions. Thank you. I'll just echo.
Go ahead. Yeah, absolutely.
Thank you. Yeah, thank you to all the panelists for joining us and for providing us with such good comments. I was going to go back. I was going to go to some of the questions. I see one about the allocation of costs of non-disputing party submissions. And it's true in some cases, and this is true in the cases brought under the Energy Charter Treaty, where the tribunal has put a cost it's usually the European Commission. The Commission wants to put in the input, and it's usually the same sort of argument that they're using, that EU member states, intra-EU member EU cases cannot go into these arbitration tribunals. It's against EU law. And so tribunals in a few of these cases have placed a cost, a cost. And the European Commission, only in one case, I think, has said okay to that. But in most of those cases, it just, it stops it. But we only know in the cases that we looked at, it only happens under the ECT and only when it's the European Commission. So it's not something that's prevalent in most of the investment treaties. I don't know, Lisa, if you want to add to that. But
no, it's just that we did see that it had a chilling effect on intervention. So that generally, if you want to encourage intervention, you don't impose a cost order on the non-disputing treaty party.
It's also ridiculous because in the pi circle of costs, this is like a drop. But if you want to do stupid things, there's a variety of avenues.
Shall I highlight another question, or Ladan, did you want to pick one to look at? If not, I'll highlight a question from Joshua Payne. The question is essentially, does it make sense to have provisions in the treaty that require dissemination of a draft award to the non-disputing parties to the treaty? Thus, obviously, at least implicitly inviting comment. I can only imagine what that could lead to under a treaty such as the Energy Charter Treaty with dozens of parties. But in a bilateral investment, it really seems to be, well, I'm starting to answer it. I don't want to do that. Does anyone feel able to comment? Anyone?
What do you do when 5 states say yes and 5 say no? I mean, that's not the moment in my view that we should be getting comments. You should try to front load a lot of this. The more you can front load it, the better. This is just going to lead to a battle of consensus and barter trading, and it's not going to be principled. So I don't know. I need to think more, but my gut reaction tells me bad idea.
Can I shift?
I think
then?
this comes from CAFTA. Sorry, guys. Sorry.
Right. Go ahead. No, go ahead, Ariana.
This is a provision that we have in CAFTA, and I think it draws a parallel with how it works in trade cases with the initial report. But I truly think that, as Kabir was saying, this is possibly not the most important moment of the process where we need to be listening to non-disputing treaty parties. We need to listen to them in between the exchange of submissions and also in the hearings, right? Because this is truly an important moment. The CAFTA provides for the participation of non-disputing treaty parties during the hearing. So I think that yes, distribution, it serves a purpose and the provision is there for a reason, but this is not the moment to start offering the tribunal new interpretations from non-disputing treaty parties.
Thank you very much, Ariana. I hesitate to go to another question. I've looked at the other questions and they have a level of complexity that causes me to think they're hard to answer in 1 or 2 minutes. We do though have 1 or 2 minutes. So anyone, something you'd like to say at the end here before I thank everyone and bid adieu to the guests? I mean, can I just say, I encountered these treaties 25 years ago as a law student. I thought, well, this is never going to fly. Allowing foreign investors to bring claims directly against states. I mean, there's so many things that are wrong with this. I can't believe it would last longer than a few years. That was in the NAFTA context. Well, I was wrong. It certainly has lasted, but it is heartening to see so many thoughtful people engaging on the issues. States, at least a lot more of them, have woken up to the kinds of risks and liabilities they assumed when we entered this new domain, where without full transparency, we have individual parties, non-states, triggering an incredible mechanism that creates so many issues for states. How to get a handle on it. This is just one sliver of the overall picture that shows the complexities once you decide that certain individual actors are going to be able to litigate directly against states, usually without going to the states' courts first. Just a little comment from the moderator. I hope I haven't abused my discretion there. I'd like to most importantly thank all of our contributors and everyone who took part today. I'm so sorry that we didn't get to all of the questions, but overall I thought it was a really nice exchange, and I'm so grateful to everyone with their thoughtful comments. So that's all, and everyone have a good rest of the day, unless we have any final word from Ladan or Lisa.
No, just wanted to thank everyone. Thank you so much, everyone. And thank you, Gus, for moderating.
Yeah, thank you all. Have a great day.
Thank you.
Bye
Thank
now.
you. Goodbye.